Welcome to AAN's 7th Regional Short Course in Miami, Florida. For those joining online, thank you so much for your participation. I'm Miriam Elman. I'm AAN's Executive Director, and in the room are several of my colleagues in the AAN leadership team, along with faculty members from across the state of Florida and the country. We've been spending 3 days together, engaging on AAN's issues, networking with one another, learning about current Israeli and Palestinian politics and developments in the Middle East, and working together to develop strategies for countering anti-Semitism on campus and in the academy. And it's really a great pleasure to be able to open this keynote to our larger membership and to our partners and supporters. We're delighted to have with us Rachel Moran, who's distinguished and Chancellor's Professor of Law at UC Irvine School of Law. Previously, she was Dean Emerita and Michael J. Connell Distinguished Professor of Law at UCLA School of Law and the Robert D. and Leslie K. Raven Professor of Law at UC Berkeley Law School. She's written over 100 articles and book chapters and commentaries on topics such as bilingual education, affirmative action, race and the law, and desegregation. She is also the co-author, along with AAN's chair of the advisory board, Mark Yudof, of one of the most widely adopted case books in the field titled Educational Policy and Law, which was published back in 2011. And in her bio for our short course program, you can read more about her many accomplishments in the field of law, her service in the field, and in the University of California system in particular. Now, I want to just mention that Rachel is a true friend to AAN, and we're so very grateful. And for many years, she has served on AAN's advisory board, where she has been and continues to be incredibly helpful to us, constantly offering good guidance. She responds to every email I send within half an hour. It's just incredible. So much good advice and support to our leadership team. And along the way, we've implemented a number of Rachel's very smart ideas, and they've proven very effective for us. Rachel's going to speak on a very important, a timely topic, the Supreme Court's university race-conscious admissions cases, which you, I'm sure, have been following, and in particular, the relevance for our work. And we're going to do things a little bit differently for this hour session. Rachel will speak for about 15 minutes, setting up the topic for us. And then she'll facilitate a group discussion in breakout sessions, and those online will also put you into a breakout room so you can talk amongst each other. Then we'll reconvene as a full group to further discuss the issues. So Rachel, with that, the floor is yours, and thank you so much for joining us.
Thank you, Miriam, for that generous introduction. I also wanted to thank the Academic Engagement Network for inviting me to be a part of this 7th Regional Short Course program. And I also want to thank all of you for your commitment in taking time out of your busy schedules to try to address these timely and important issues on America's campuses. So I wanted to begin, and of course my slides are sticking now. They were working before we tested them, so I'm actually going to stop my share and reload them and see if that takes care of the problem. There we go. There we go. They needed to be reloaded. So as Miriam mentioned, I wanted to talk with you today about the pending affirmative action cases before the United States Supreme Court. As I'm sure all of you are aware from the media coverage, the court is hearing 2 cases, one involving Harvard College and the other involving the University of North Carolina. Now, these cases are noteworthy for a couple of reasons. One is that when the court has heard challenges to affirmative action in higher education in the past, the defendants have always been public flagship universities, places like the University of California, the University of Michigan, and the University of Texas. So this is really the first time that we see the Supreme Court hearing litigation against an elite private institution. And I'll come back to that in a moment. Now, it's clear that the court wanted to hear these two cases together, because what happened was the Students for Fair Admissions, which filed these lawsuits, had as its strategy that it would litigate against an elite public institution, an elite private institution, and then they would come up as companion cases. And then a monkey wrench got thrown into that plan, because while the Harvard case proceeded expeditiously, the North Carolina case got bogged down, and there was a lot of delay in getting the district court decision. So the court had granted certiorari to review the Harvard case, and the district court in North Carolina still hadn't issued a decision. So what's so interesting is when the district court did finally issue its decision, the court granted a motion for expedited review. So there was no circuit court, appellate court decision in the North Carolina case. It went straight up so that the cases could be heard together. I think that's a strong signal that the court is going to do something important for both public and private institutions of higher education. And it really didn't want to do that piecemeal. Now, when you read the media coverage, I think that Harvard gets the lion's share of the attention in the coverage. And I think there are some reasons for that. One, of course, is that it's the first time a private institution has been before the court. But also, I think, Harvard is unique in the public imagination about higher education. It's sort of like the equivalent of Lifestyles of the Rich and Famous comes to the academy. And so what the case has done is allow people to get an inside look at how admissions operates at an institution that's as highly selective as Harvard. And bit by bit, we have seen, for example, that the weight that is given to legacies, children of donors, children of alumni, children of faculty, is probably more substantial than people had thought. And that's gotten a fair amount of attention because the feeling is already privileged people are getting an additional advantage. Now, the next thing that's gotten a lot of attention in pulling the veil back from admissions practices is that Asian Americans had the most competitive academic credentials when measured in terms of grade point average and standardized test scores, and yet they had the lowest rate of admission. And to justify that, Harvard officials cited the interviews and personality factors. And so this highly subjective part of the process became far more salient to people. And I think that finally, Harvard is important in the affirmative action story because in the first case in which the court upheld the use of race in admissions at America's colleges and universities, it did so by citing Harvard as the example, the best practices in using race in admissions by refraining from quotas and just treating race as one factor in holistic review. So Harvard has this very special place in the annals of the court's jurisprudence on affirmative action. Now, what I wanted to do today was just take a look at what's at stake in the case. And, many people see affirmative action in higher education as solely about racial equality and equal protection law. And that's a part of the story, but it's not the whole story. Because elsewhere, if you look in other facets of radio broadcasting licenses, employment, elementary and secondary education, the court has said when it's just about race and equal protection, we can only use race in our decision-making as government actors if there's been a history of past discrimination that we need to remedy. So in other facets of American life, we don't allow institutions to voluntarily use race in their decision-making absent some finding of past discrimination. So higher education has been unique. It's been anomalous because for decades, the court has allowed colleges and universities to to consider race as part of the admissions process, to do it openly. Now, why is that? Well, the court said that these institutions of higher education are unique because of academic freedom, that these colleges and universities have certain freedoms as institutions. These aren't the professors, these are the schools themselves. And one of those is to compose the student body. And in composing the student body, the court said, colleges and universities might use their expertise and discretion to conclude that they needed diversity in the student body. Diversity is not just about race and ethnicity, the court said. It's about all kinds of other things, background, experience, where you grew up, all these other factors, but race could be one of them. Now, the court therefore said that under our jurisprudence, diversity can be a compelling interest. It rejected this as a compelling interest in elementary and secondary schools later because they don't have academic freedom akin to that of colleges and universities. But they said for America's institutions of higher education, diversity is compelling. But they also said this is still race. And where race is concerned, we very much worry about the government using that as a category for decision making. And so we're going to subject these programs to strict scrutiny. And so even though diversity is compelling, be narrowly tailored to achieve the goal of diversity. So you can't use this loosely or broadly. You've got to use race in very targeted ways that are necessary to achieve your objective. And there is no other way to do it by employing race neutral alternatives. So it's a very strict standard of scrutiny. Now, after the court allowed affirmative action using race in admissions, it has revisited the issues on several occasions. In the early 2000s, in lawsuits against the University of Michigan, the court really emphasized narrow tailoring. And it said you can use holistic review with race as a factor, but you can't use mechanistic point systems that accord a set number of points to a racial identity. That's not appropriate. And then later in lawsuits, just in the late, in about 2017 against the University of Texas, the court said that you couldn't use a good faith standard to evaluate whether race was still a necessary part of the admissions program. There, the University of Texas had been prohibited from using race under a Court of Appeals decision that was overturned by that Michigan lawsuit that came up to the court. And so after having used percentage plans to achieve diversity on a race neutral basis, after the court's decision in the Michigan cases, Texas reintroduced the use of race at the margins of its admissions after filling most of the class through its percentage plan. And the court said, you've got to show us why it's still necessary to use race in this way. And so Texas went back, it did some studies on feelings of isolation among underrepresented groups, and also the lack of representation of those groups in some of its classes, and the court upheld the program. So given that the court just upheld Texas's program about 5 years ago, one question is why now? And I think everyone, and you've probably read the speculation yourself, is assuming that the court is going to overturn affirmative action. Now, the real issue, for me at least, is what grounds will they use? Because one potential way to decide the case is to say, you know what? Diversity is not a compelling interest. And therefore, race is an impermissible factor in admissions programs everywhere. And unlike the recent decision overturning Roe versus Wade and the right to abortion, there will be no political counter response because it will be unconstitutional to use race, and you can't pass a statewide referendum authorizing the use of race if diversity is not a compelling interest. There are ways to decide this lawsuit more narrowly. I think there are at least two. One of them would say that yes, diversity is compelling, but these programs were not narrowly tailored to achieve that objective. They didn't fully exhaust race-neutral alternatives. They should have done more to minimize the use of race in admissions. And therefore, we're going to make them go back and redo their programs. Another possibility, particularly in the Harvard case, is that the court could find bias, discrimination against Asian American applicants, and overturn the program on that ground. Now, I don't know for sure how the court will come out. I think there are several members who would likely say that diversity is not a compelling interest. I think they've already said in earlier opinions. But you also have members of the court, for example, the Chief Justice was rumored to have tried to broker a deal in the abortion case to find a narrower ground for decision, less controversial, less incendiary, and failed. So he might try to broker a deal. And we have some members of the court who are kind of an enigma. We don't really know where they stand, like Justice Kavanaugh, Justice Amy Coney Barrett. So we don't know exactly how the case will come out, but I do think we know that it's not likely to just affirm the status quo. That means that every college and university is likely to be grappling with what to do after the end of affirmative action in some form. And one question will be, is it only going to be public schools that have to grapple with this? And I think the answer is that the court took the Harvard case because it wants to say that if you accept federal funds, as Harvard and virtually every other major university does, you're subject to Title VI of the Civil Rights Act. And Title VI contains a non-discrimination provision that is coextensive with the Equal Protection Clause. So I believe that unless a private university is willing to eschew the use of federal funds, it's going to be subject to this ruling as well. Now, that means colleges and universities will have to worry about what they can do, and given what they do, whether they're going to be subject to further lawsuits, whether they're going to be targets. Let's say the court ends diversity as a compelling interest, and colleges and universities choose race-neutral alternatives. Well, there are already noises from conservative organizations like the Pacific Legal Foundation that they will sue over race-neutral alternatives that are facially neutral, but motivated by a desire to promote greater racial representation in the school. And so I think you'll likely be subject to suit. Let's say that they say diversity is compelling, but your programs have to be narrowly tailored. Well, we saw from the Grutter, the Michigan and the Texas cases that that's going to be the subject of litigation. If you used race, did you use it too much? And could you have used race-neutral alternatives? If they were to decide this on the basis of discrimination against Asian American applicants, I think the litigation would still continue, but it would be about how the use of standardized test scores and grades are combined with subjective decision-making that might introduce bias into the process. So with that, I wanted to say, what is at stake for our Jewish students? And the interesting thing is that the affirmative action debate has largely ignored the issue of Jewish students and Jewish admissions. But that doesn't mean the Jewish community hasn't been active in these cases. And in fact, there were 3 amicus briefs filed. And what to me they reveal is the division within the Jewish community about affirmative action. They're really all over the spectrum here. So you have the Brandeis Center, and it filed a brief in support of the plaintiffs, the Students for Fair Admissions. And it said that Harvard in particular is wrongly using quotas. And I'll come in a moment to a little bit more in-depth exploration of that argument. And then the Jewish Coalition for Religious Liberty said, we're neutral. We're not filing on behalf of either party, but we want to emphasize that schools have unduly diminished the salience of religious diversity. They haven't done enough to promote religious diversity. And then the Anti-Defamation League filed a brief in support of the universities and Harvard, arguing that these are not impermissible quotas and they don't reflect any discriminatory intent. So I just wanted to share with you a little of the language, and I think the briefs were part of your reading material, so you may have already looked at these, but the Brandeis Center brief really got the most attention. And that's because the Brandeis brief said Harvard should never have been the model that the court invoked, because embedded in Harvard's history of admissions was a set of prejudicial practices that excluded Jews in the 1920s and 1930s. And they emphasized in the brief, if you go and read it, the growing numbers, because they used, it wasn't as selective, Harvard wasn't as selective then, but they were really driven by academic credentials, and Jewish applicants did very well. And so their numbers were growing very substantially. And President Lowell of Harvard was worried that this growth in the number of Jewish students would offend, upset alumni. And indeed, he had an alum who said, you know, I went to the Harvard game and I was surrounded by Jewish people, and this was very, very unpleasant for me. So Lowell thought that if Harvard was to remain prestigious, keep its alumni happy and donating, they had to do something about what he called the Jewish problem. And so what they did was not to say we're not using academic credentials. What they did was introduce the subjective part of the admissions process, which looked at character, and in that way constrained the number of Jewish people granted admission to Harvard. And so essentially what all over again, Asian American applicants are similarly having their academic credentials discounted through a subjective process that gives them lower scores for their personality and leadership. Now, the Jewish Coalition of Religious Liberty, this is interesting because I read the oral argument in the cases, and some of the justices actually expressed views that were represented in this brief. So Harvard, the Jewish Coalition of Religious Liberty said, actually erases religion in the admissions process. Instead of promoting religious diversity, it makes it very hard to achieve it. How? When you're an applicant, if you put your religion down, it's redacted from the admissions file, so nobody can see it. And so the only way you can find out someone's religion is if they include it in the personal statement. And so the justices actually said, isn't it true that you make it very difficult to figure out religion? You don't consider religious diversity. Isn't religion an important part of a person's identity, a fundamental part of our nation's history? And so this brief actually did have an impact, I think, on some of the justices, at least as reflected in their questioning during oral argument. And then finally, the Anti-Defamation League said, we oppose quotas. We agree that Harvard had a shameful history with respect to quotas, but we don't think that's what Harvard is doing now. We believe that this truly is holistic review, born of good intentions that are inclusionary, and we therefore shouldn't create a false analogy. And we support what Harvard is doing, even though we reject quotas, and we rejected them in Bakke, where we filed a brief saying you can't have set-asides in the entering class. So for me, this reflects the fact that Jewish organizations feel a stake, but there's tremendous heterogeneity in how they're approaching the issue. Now, this brings us to the question of the aftermath. If, as most commentators predict, the court strikes down affirmative action, we'll either see it saying, as I mentioned, diversity is not a compelling interest across the board, no more affirmative action, or the programs have to be narrowly tailored, which means race can't be given too much weight, and that will lead to lots of anxiety about the prospect of litigation. And schools will, I think, under either approach, declaring that diversity is not compelling or that programs are not narrowly tailored, they're going to have to look at race neutral alternatives very, very carefully to avoid, at least to try to avoid litigation. And I think that, we included in the packet a reading. And I think some of the kinds of race neutral alternatives we've seen in the press involve things like socioeconomic status, immigrant status, language proficiency, and then also activities and commitments that relate to social justice. But what I wanted to do during the breakout exercise was to use this article as a sort of a springboard into the discussion of what colleges are likely to do if they can not use race and admissions in the same way that they used to. And I think every college and university is probably going to approach this differently because they have different cultures, they have different amounts of resources, and allow you to think about what your own college or university is likely to do if the Supreme Court strikes down affirmative action and admissions. What will it do if it wants to preserve diversity in the student body, but doesn't want to use an impermissible means? And I also wanted you to think about how those changes might affect Jewish students. And I think we need to move beyond just the application to school, which is important, but also the climate on the campus in the wake of the end of affirmative action and how that might affect Jewish students. And so during the discussions, as Miriam mentioned, I want to get report backs. I'm really curious and eager to hear what you come up with. I would like you in your group to select a facilitator to moderate the discussion and a reporter who will share the findings with us when you come back from the breakout. They can be one and the same person, but they can also be different. But I do want to make sure that we have a reporter so we can have a nice set of kind of summaries of what you found and then perhaps some discussion. So at this point, I'd like to go ahead and break out into the groups, and I'm going to leave that to the talented AEN staff to get the breakouts going.
What group would like to go first to report out your key points from your discussion? Yes, go ahead.
So, in terms of what else a college or university can do, one of the programs that we have in Florida is that we take a certain number of students from the top 10% of every high school.
Yes.
Okay. Another thing that Harvard did years ago, when there were too many people at Harvard, was they started to take a percentage from each region in the country. And when you're taking a percentage from, let's say, the upper Midwest, right, you get a few pros and shows in Minneapolis. I love the history of the Jews in Minneapolis. And consequently, you can diversify. One person suggested that we do it economically. And if you take a certain percentage of kids from low-income backgrounds, right? And I don't know, my knowledge of demography tells me that probably doesn't work in most places for the following reason. While a high percentage of Black students in particular, not Asian, Black students in particular are low income, most of the people who are low income are white. Right? So that I'm not sure that solves the problem. And an issue I brought up that I don't have an answer to, and I'd love to see I brought it up in the group, and I'd love to see our speaker address is. I think it's one thing if you have a level of enrollment at your university, let's say for undergraduates. You generally, University of Miami has been allowing in 2,000 undergraduates each year for freshman class, right? For 30 years. If we then turn around and say, let's leave affirmative action out of those 2,000, but after those 2,000, let's let in 100 Black kids who look like they can do the work, right? You're not costing any white kid or Hispanic kid, we're mostly a Hispanic school. Where any white kid or Hispanic kid a position in the freshman class. Whereas at our medical school, we allow in 100 people total, okay? If you let in a less qualified Black student, let's say, in order to diversify the medical school class, then you are costing a white student a position. On the other hand is, what if you, particularly for law school and medical school, and one of the first cases here that came up right years ago was a guy who applied for a white student who applied for law school, I think in Oregon or Washington, right? Didn't get in and sued over this. What if you had a promise from that student that we're gonna admit you to law school, right, at the University of Miami, but for 5 years after you get out, you're opening up an office in a black area town, one of the following cities. Okay? And, you know, that would also solve another problem we have in this country that I can tell you as a geographer, called misplaced hospitals and doctors.
Yeah.
We have too many hospitals and too many doctors here in Miami. We have all these other doctors, okay, who, and there's such a market here that we've got more doctors and hospitals than we need. And then there are other areas of town, right? So you could say to any color student, if you're willing to spend 5 years on a Native American reservation, then you're gonna get some preference and cover. And to me, that's another possibility. And I have difficulty with all of these things, because in the era that I grew up in the 50s and 60s, it's let's get rid of looking at people's race. It was don't put pictures on, don't require pictures on the thing, right? Stop asking for your mother's maiden name to find out if someone's Jewish. That was what I grew up with. So I have some problems with all of this. Gentlemen, did I miss anything? Nope. Okay.
All right, let's go to this group, yes.
What?
Okay, it's me. Guys,
Oh,
okay,
yeah, they're made, okay.
same, finish. Okay. This group, we discussed, for example, financial aid, if a student receives financial aid like FAFSA, to Pell Grants or whatever, does that, to a private school, does that affect their position? The private school is then receiving government aid. We assume that they are. But what we discussed mostly is what might be some options for pursuing diversity. And at one point was that this is the post-industrial age. Education is the key. It's the way to social mobility, and it is vital for particularly for minority students of color. We also talked though about the unfair effects, the difference of 500, 400, 500 points higher test scores for Asian American students are required so that the playing field is not level. And the question becomes, why should Asian Americans have to pay the cost for African American discrimination? I have to introduce, I didn't mention it, but the idea of reparation for historical injustices. And I think that that still functions as a necessary thing, but we didn't talk about it, so I just said it. Okay, and then there's question is, will there be a backlash for Jewish students, Asian American students? And one of the things that we mentioned was that there's no affirmative action allowed on the UC system anymore, but they maintain diversity in other ways. That including retention efforts by sending recruiters, minority recruiters into minority communities. Another point, though, that points are offered on whether point systems for that are immutable characteristics, and is that reasonable? I think I'm saying that right. But finally, the racial categories as they stand currently are absurd. And the question becomes, what does diversity actually mean in today's world? Who are we talking about? And that brings to the point about reparations. Is that legitimate or not? Is it reparative, or is it to create the better community on campus? That's it.
Right. And then our last group, please.
Yeah, thank you.
We never.
But we discussed, we realized that this is can be very different in depending on the university and campus and size, and if they are more popular than others, and so the situation might be very different in a small college or a public university or a very prestigious university. In some universities, I found there is not much of selection, affirmative selection, because they don't have so many applicants. That's what I. So, it doesn't mean they take everybody, but they take many, and then that's not a like high level on the criteria. And then also on the impact of Jewish students, we were not sure if that has a direct impact or not, especially if that is not, like, has not so far benefited Jewish students and the affirmative action. But we also mentioned that there might be some, or I mentioned that there might be some conspiracy theories coming up, because this is usually affirmative action is, I think, usually popular in the among students and among faculty, and some of them will then likely be looking to blame somebody and blaming Jews, saying, okay, they put the Jews put the Asians forward, and that's why this was struck now, and I expect these countries. We had also discussed an ideas about what university I think are doing anyway. To diversify the student population is diversify the pool of applicants, have good accommodation policies that are good for minority students, encourage student groups where they feel comfortable than minority students, or students from minority groups. So that might be a way how universities will then try to get around this. That's, I think,
Okay, Rachel, so all three of our groups were able to present.
This is great. And I'm going to have to reload. The slides get stuck, I guess, if they're not used. But let me go back and let's see if I can get the slides to move over, because I feel that the groups really came up with some very important points that I think are really worth considering. So let me just, I'm going to have to reload them from the beginning. Sorry about that. We keep having that problem, but eventually we get it resolved. So I think a couple of really important things came out of that. One is that people recognize that universities, colleges and universities will likely remain committed to these values. They've been institutionalized and embedded in offices of diversity, equity, and inclusion. So whatever the court decides, they're not going to go away. And I think that several of the race neutral options that were described, the percentage plans already in use in states that have banned affirmative action in higher education, socioeconomic status, there was a suggestion that perhaps some commitment to doing certain kinds of work later would be permissible. I think, that might be a riskier strategy, but the claim would be it's not about racial identity, it's about serving communities. Now, in the Bakke case, the court actually said that universities didn't have a stake in rectifying broader societal discrimination, including what I think was called the misplaced hospitals and doctors. And so whether or not that would be viable is a real issue. We know that even with percentage plans, financial aid is very important. And one of the things that the Bakke decision did, and this goes to reparations, is it rejected remedial justifications, ways of rectifying past discrimination, and really focused on this First Amendment rationale, this ferment of ideas. And so in that sense, it makes it harder to have the conversations about remediation based on structural problems, because you have to show the institution itself engaged in discrimination, and that typically hasn't happened. At least in California, they have allowed colleges and universities to continue to do targeted recruitment, but whether that would be challenged, we don't know. I also thought that it was very interesting that there was a concern about what these categories even mean, that they're sort of not so clear cut and maybe in flux, and also that perhaps there might be some sort of backlash against groups that are perceived as privileged and somehow part of the reason why affirmative action is gone. And that actually brings me to some of the thoughts that I had that I wanted to share with you, and a final problem that I'm going to at least share with you, even though we can't work it through in the same way. Because, you know, one of the things that I think we've seen is that offices of diversity, equity, and inclusion have not been particularly concerned with the experience of Jewish students and anti-Semitism. That I don't think that's been a high priority within most of these offices. And when I was getting ready to give this talk, I actually read a book by David Badul, who is a British comedian, screenwriter, performer. And he wrote the book with the idea of the United Kingdom in mind. And he called the book Why Jews Don't Count. And in particular, he wanted to interrogate the question, why is it that progressives don't attend to the Jewish experience and anti-Semitism? And, you know, and I think with the end of affirmative action, the attention span will be even shorter because there'll be so much concern about the loss of students of color. But his theory was that Jews had been characterized as white and privileged, and therefore they didn't deserve to be a protected class within these offices. And he actually, because he's in the entertainment business, he used the example of controversies over, for example, hearing actors portraying a deaf character in a play or a movie. And the critiques of that is a kind of an improper appropriation of a disadvantaged identity. But he noted that Gentile actors, non-Jews, play Jewish characters all the time, and nobody says anything. And he says, this is an example of how the perception is Jews aren't disadvantaged, so that's not improper appropriation of their identity. But what I also thought was interesting is that elsewhere in the book, he actually implicates this question of what is Jewish identity, how complex it is, how layered it is, how kind of culturally ambiguous it can be. And the way he raises this is with the sitcom Seinfeld, and I'm sure all of you are familiar with it, but when Seinfeld was airing, there were people who would write in and say, why is Jason Alexander's character called George Costanza when he's so obviously Jewish? You know, what is that? Well, the backstory, according to Badul, is that when Larry David and Jerry Seinfeld went to the network with the idea for the sitcom, the executives said, you know what, it's a great idea, Larry, Jerry, we love it, but there's too many Jewish characters. You can't have them all be Jewish. We won't get an audience in prime time. And so what Larry David and Jerry Seinfeld did was just rename two of the characters, George Costanza and Elaine Bennis, but they didn't do anything else. They didn't change the script. They didn't change the casting. And so they said, you know what? We'll just do exactly what we wanted, but two of them will have non-Jewish names. And that took care of it. And so it suggested that, you know, there's so much ambiguity around the identity that you can do something like that and it's sufficient. But it also, for some people, raised questions, you know, why is Jason Alexander called George Costanza? So I think the heterogeneity of the Jewish community, along with the perception that it's white and privileged, may be playing a part in this ambiguity. And we also saw that heterogeneity in the Supreme Court cases themselves, with Jewish organizations filing on behalf of Students for Fair Admission, Harvard, and neither. Now, I think that ambiguity creates some problems for addressing proactively campus climate in offices of diversity, equity, and inclusion. And so they only tend to be reactive. That is when there's actually, you know, a hate crime, which is undeniably discrimination, that the offices will get involved and take some steps. But the problem with that is that just reacting to the worst case manifestations isn't sufficient to change the climate and prevent those actions. And I think it will be even harder to be proactive if affirmative action is ended, because all the energy is going to be directed at the problems of losing students of color. And finally, I want to say, not only is Jewish identity very complicated, but I think the meaning of anti-Semitism has been complicated. And I wanted to end with a case that I think has already come up in your training program involving University of California, Berkeley Law School's student organizations, which adopted a bylaw saying that they would not invite speakers who support Zionism or Israel's policies, and also stipulated their support for a movement that is designed to challenge Israel's policies through boycott, divestment, and sanctions, and also required members to participate in training on the plight of Palestinians. Now, that action triggered real controversy, and I have this California magazine, and there was an article, an interview with the dean at the law school, Irvine, but the title, which you probably can't read, is Jewish Free Zones on Campus. That's on the cover. Now, this action triggered complaints from alumni, faculty, and other students, and I know that the Academic Engagement Network worked with concerned faculty and administrators to address what had happened. But what's so interesting is that the dean said this isn't necessarily anti-Semitism. This could be just an ideological position, and everyone is free to have ideologically based goals, restrictions, priorities based on their values. And so here is the quote from the article, student groups can always choose speakers on the basis of the viewpoint of the speakers. And Jewish law students don't have to invite Holocaust deniers, or the campus Republican group doesn't have to invite socialists, or Black law students, white supremacists. But there can't be discrimination based on race, religion, sex, or sexual orientation. And so this line between what is an ideologically based action, free speech, and what is actually anti-Semitism is really complicated. And I want to say this is also working in the opposite direction. Just this week, I read about Kenneth Roth, who ran the Human Rights Watch, and he had been invited for a prestigious fellowship at Harvard. And because he took very strong views on Israel's policies, calling them akin to apartheid, he was disinvited. They rescinded the invitation. Now, Roth is himself the son of a man who as a young boy fled Nazi Germany and the Holocaust. But they felt that his views were not just free speech, but reflected bias against Israel and disqualified him for the fellowship. So this question of, what is an opinion and what is bias is really tricky. And so I hope, although we don't have time for another breakout session, that you will think about how your campus would deal with these kinds of student bylaws or that kind of invitation for a fellowship, and how you would frame this yourself. How would you like AEN to help you to address whether this is ideological and thus free speech, or whether it's actually anti-Semitic and thus impermissible discrimination? How can you get help with that line drawing exercise? Finally, I wanted to end with what I feel are some constructive alternatives. I think focusing all energy on offices of diversity, equity, and inclusion is not going to be a good idea when they're going to be overwhelmed by what happens after affirmative action is likely ended by the court. But there are many ways to create a friendly climate, a positive climate. And so for people who aren't going to have that happen through the offices of diversity, equity, and inclusion, I think it's important to think about other ways of educating the student body about the Jewish experience. And I recently read about some wonderful exhibits and performances that were happening at college campuses focusing on the Jewish experience. And so I hope that you will think of other ways to create that positive campus climate in the event that your Office for Diversity, Equity, and Inclusion is only likely to respond to the worst case manifestations of hate. Again, the worst case manifestations of anti-Semitism, because I really think that's just the narrowest sort of approach. We really need to broaden the approach to create a more sustained understanding And I think there are many opportunities at campuses, and I hope that some of the talented people who are participating in this training will come up with creative ideas to do that. So thank you very much for your time. It's really been a pleasure. I've enjoyed talking to you, and I wish you well with the rest of the training.
Thank you so much, Rachel. This was such a rich discussion that facilitated for us, and we are actually great. We're going to go outside because it is Miami, and it's 80 degrees. And tomorrow we're all heading back to -20 and God knows what. So we're going to head outside, but we purposely put your session before our group work so that we could continue to talk about the cases that you raise, including Berkeley, the issue of how to address DEI on campus, and there, as you know, some campuses doing a little better, but many, as you point out, just we're not there. We don't have a seat at the table. And they're not addressing our issues and our concerns sufficiently. So we're going to do breakouts and continue to talk about your session. And thank you so much for all the work that you do. We'll certainly be back in touch. As you know, we'll be meeting soon. So you won't get too long of a break from AEN. We'll get you back into conversation, Rachel. Thank you so much.